Thanks, yes. So I've altered my title. There's a connection to equity in what I'll say. I'm interested in the juridical power to bind others in Kant, and I'll mention a quotation from Paulina to bring out the connection to mere means in just a second. My concern and topic is that powers to bind juridically are unequally distributed throughout our societies, contrary to what Kant says about innate equality and civil equality. Pervasively so in a society of corporations where people occupy offices and dispose over corporate resources. We exercise powers to bind that are not shared equally with others. So we have the Shakespeare sonnet, one of the most beautiful and enigmatic of them, they that have power to hurt and will do none. My connection is that we move in societies where lots of people have powers to bind, and it can't be that it's just a matter of our personal wills with how we exercise those powers. If we're going to have powers to bind that are not shared or distributed equally, then there must be counterbalancing powers to bind to make sure that those juridical powers are used in a way that's compatible with innate equality or civil equality. Hopefully that will become clear as I say a bit more about corporate powers and how we occupy those all the time. The connection to means and ends, that will come up towards the end of my talk, but I wanted to highlight something that Paulina commented on just in a paper from earlier this year, which I thought, like all insightful comments, you read it and you think, okay, that should have been obvious, but it wasn't until it was said. We can understand the prohibition on instrumentalization in Republican terms. Using someone merely as a means or failing to treat someone as an end in themselves is going to involve some sort of domination over another person. It fits together with Kant's basic Republican commitments to our having equal powers to bind one another. And my basic problematic here is that when we exercise, I don't know, my power as a university lecturer to grade my students, I exercise an unequal power to bind over them. I determine their grades, their degree results, and something about their future life chances. That power has to be rendered compatible with Kant's Republican commitment to equality if it's to be admissible within his system. So, if we have unequal powers to bind, then we should not be surprised that some people suffer instrumentalization or worse in our societies. Obviously, I'm not instrumentalizing my students because I am bound in my turn to the exercise of that power that I have over them. I want to start with the idea of innate equality and then also how Kant frames this within public right as civil equality. So, right there at the start of the doctrine of right, we have the idea that we should each enjoy innate freedom on equal terms with every other person. So, each person, this is the Republican idea, should be independent from being bound by others to more than they can in turn bind them. We're only our own masters if we live on terms of equality with one another. Of course, we bind one another all the time. Hands off my laptop. Meet the terms of the contract that we have made with one another. We bind one another all the time, but we do so enjoying the same rights and the same power position vis-a-vis one another. That's the starting point of the whole doctrine of right, and then Kant specifies what happens to that within a civil condition later on in the section on public right. Civil equality, none of us should have to recognize a superior among the people. We recognize a legislator, our united will, but none of us should have to recognize a superior among the people, except one who has the moral capacity to bind juridically in the same way as the other can bind him. And I use that quotation as well as the first one because I think that's a nice way of making a bit clear what this power to bind is, the moral capacity authorized by law to exercise power over another person. And also because most of us have been embarrassed as we read the doctrine of right, that Kant doesn't seem to fully recognize the implications of this principle and says that some people, despite this idea of civil equality, can be passive citizens and be bound by laws in which they themselves have no say. So I want to bring out the radical quality of this principle and the difficulty of applying it to a society where there's all sorts of inequalities of status and power through the social fabric. My analogy that I want to use with the case of domestic right. Kant seems not to recognize that civil inequality should not allow some people to be heads of household who lord it over wives and servants. Should we not recognize, and I'm going to use the idea, no, I'll come back to the French Revolution in a second. Should we not recognize that people's power to exercise, to dispose over resources that aren't their own, for instance, the resources of a university or a business corporation, is also contrary to civil equality? Let me spell that out with a revolutionary guillotine for you. So, the French Revolution declares principles of liberty and equality, Article 1 of the Declaration of Rights of Man and the Citizen. Part of what follows from that for the revolutionaries is the abolition of corporations. The nobilities, the church estates, the guilds, the manorial jurisdictions, the tithes, all the feudal stuff. Also, as you might know, attempts by workers to combine with one another to form another sort of corps in the CORPS sense, another sort of body corporate, a trade union. The guillotine falls down with the French Revolution on every sort of corporation in French society, not just the ones we associate with feudalism. Ooh. So this is Article 3 of the Declaration. The principle of sovereignty lies primarily in the nation. There should be no core, no corporate body that exercises any authority that doesn't explicitly stem from the sovereign. As I say, that then turned into a carte blanche for the abolition of all these bodies that bound their members, that sustained the feudal order, but not just the feudal order. Now, Kant's not going to follow the guillotine so radically. It's not going to be an overnight revolution for Kant. We know he's reformist rather than revolutionary. But that wording that you saw in the article there, it is just the spirit of the doctrine of right. There should be no body corporate, there should be no individual authority beyond our private rights, except that which expressly emanates from the state. That's Kant's principle. Why does he not argue for the slow death, if not the sudden beheading, of every corporate body? So if you look at what he argues with regard to different sorts of corporations within the doctrine of right, we have an argument that no foundational corporation could be perpetual, only the state can be perpetual, exactly the same as Article 3 there. He explicitly endorses and the wording, I hadn't realized this until just preparing for this talk, the unbelievers of the French Republic who want to abolish ecclesiastical estate. Kant comes out right in support of their abolition, if not overnight, then gradual withering away. He absolutely insists that the state has the right to reform and even abolish any body corporate. What he doesn't do is argue that the state has a duty to abolish them all. And that's what interests me. How can Kant think that it is tenable to have corporate bodies which involve, as I'll explain in a second, powers to bind within his commitment to innate equality and civil equality. How can that be? Every corporation is a distinct or artificial legal person. So what I mean by that is a university, a trade union, a church, a charity, a business corporation. Under law, it has its own rights and duties that are distinct from the rights and duties of the individuals who take part in it. So, the English phrase, a corporation can sue and be sued. It is a legal entity that has its own debts, potentially its own liabilities if somebody's injured by the negligence of corporate participants. It is the artificial legal actor that is liable. So, its own property, its own contracts, its own debts, its own liabilities. I want to say that poses an intrinsic threat to our equality, our civil equality, as having equal powers to bind. Obviously, an artificial person, an entity that just exists in law, can't do anything unless actual people do things for it. So there need to be lecturers and officers and trustees and employees and members who act within and for and represent the corporation. The corporation gets taken to court, somebody must speak for it. For instance, the corporation has a debt to answer, someone must sign the checks. So actual living, flesh and blood human beings must fulfill the corporation's duties and exercise its rights. That means those people do not act. We've got a set of revealing idioms in the English language. They don't act in their own name. They act in the name of the corporation. They don't act exercising their own rights. They exercise the rights of the corporation. They don't act on their own account. Very literally, if they take out a debt for the corporation, it's not their bank account, it's the corporation's bank account that the repayments have to come from. So you've got people exercising powers to bind, juridically binding powers that are not their own as private individuals. So what we've got, and this is why I say there's an intrinsic threat to civil equality with the existence of these artificial legal persons, you've got people who can exercise these binding powers, the corporation's rights to own or dispose over property, or to award degrees to students, or to call strike action. They exercise that additional power to bind, and they're freed from some of the normal liability that they would have as private individuals. So it's the corporation that is sued, primarily if it fails to repay its debts. Actual people decided on those debts, other people lent the money, but the corporation is bound, not the people who took out the debt or the mortgage. So does that make sense? The idea that as soon as we have an artificial legal person, then people have to act for it, and they're exercising binding powers, in Kant's terminology. The liability, the duties that are incurred by those powers are not theirs as individuals, but fall to the body corporate. And that should not be on the idea that we all have equal powers to bind. We all have equal powers to bind under private right, our property rights, our contract rights, our personal rights to freedom. But yet we live in a society and we take for granted that people enjoy these additional powers, some people enjoy these additional powers to bind. Larissa, I'm going to ask you just to keep me on track for time and maybe give me a warning in 10. Thank you. So, I want to say this isn't just a problem for the feudal corporations. Of course, guilds and manorial jurisdictions and all the rest of it had the point of creating a hierarchical social order where a few people had privileges to bind and many people were bound. As Kant puts it, we had corporate orders that were dedicated to disrupting civil equality by removing what he calls the only natural division between sovereign and people. If you take civil equality seriously, then every person has the same rights. There aren't any lords among us. There aren't any people with superior powers to bind. Perhaps I could just add that has not seemed at all natural to most people in human history. It has seemed absolutely natural that there would be hierarchies throughout society, but Kant is a revolutionary in a certain sense. This principle of civil equality has radical implications for how we organize our lives. We may take for granted, but we no longer, I think, see the difficulty, the tension with these powers that people occupy within offices and organizations. So I'm wanting to say, not just the feudal organizations, but all corporations, regardless of their size or their purposes or their powers, empower some people to do things that they can't do with their private rights, create unequal powers to bind. Of course, the feudal corporations deliberately did that, but it happens also with universities or trade unions or business corporations. Some people exercise those powers. Those quotations I started off with, the moral capacity to bind juridically to more than others can in turn bind them. Or in slightly different vocabulary, we no longer act in terms of our private rights, we take on the rights and powers of another, the artificial legal person. Now you might say quite often the effects of this are very slight. So we just have a little private local corporation for running our tennis club, or maybe even our bridge club. Hardly affects anybody. The property involved is very slight. Many corporations only affect a few people. You have a co-op to run your flat building, for instance, a condominium. British Philosophical Association, of which I'm treasurer, for a lot of its history, commanded only a few £1,000s, so it's hardly as if I'm going to be taking out a huge mortgage and binding people with that power. I'm also very tightly regulated as a charity trustee, so there's very little chance of me abusing that power. You could imagine a wholly democratic corporation like a co-op. You might say, well, everybody involved has equal powers to bind within that. They all make decisions together. But still, they act juridically vis-a-vis outsiders. But maybe they're all well-intentioned and it's all harmless. Materially, the effects may be very slight. They may also be, and I won't labor this point, but I'll just put it up on the slide, the material effects can also be vast. If we think about the organizational fabric of our societies, we've got, maybe just stay with the commercial example there in the middle, we've got bodies that are near monopolies that control the flow of information or the flow of financial systems. These powers can be vast, although they are often trivial. But Kant's account is formal rather than material. Of course, for all the rights that Kant sketches, the matter of those rights can vary enormously between people. That's the point about matter. It's multidimensional. Its extent, we can judge it in different ways. Our property, for instance, varies enormously. It couldn't possibly be the case that we have materially the same holdings of property, but formally we're equal because we exercise the same rights. And I want to say the same thing should apply to the level of corporate powers. Of course, the extent, the material implications of corporate powers vary vastly between the British Philosophical Association and, I don't know, Meta or Nestle or Oxfam. The powers vary enormously, but still formally there is inequality introduced, and that, I think, should be of concern from a Kantian perspective. You act for a corporation, small or large, you get more legal power, less legal liability. That seems, on the face of it, to be incompatible with civil equality, our equal powers to bind. That's the core problem that I'm working with. unless we have to bring down the guillotine, or at least slowly strangle all corporate bodies, how can these powers to bind be made compatible with Kant's basic commitment to equal freedom? If the problem is formal, then Kant has got to insist that the remedy must be formal too. We need to look at the ways in which the people who occupy, or the corporations which enjoy these additional powers, are bound. So that's the, to go back to my original title where I mentioned the question of equity, if I enjoy additional powers to bind, for instance, as a parent can bind their child, there have to be counterbalancing legal powers, legal duties, to make sure that I do not abuse that power, so that I am bound to fulfill my parental duties responsibly, that there are legal counterbalancing measures against that. One of the problems with Kant's category of domestic right is that there seems to be no counterbalancing powers. Even if you think, with patriarchal ideas, that women need the care and protection of their husbands, where is Kant explaining what sort of safeguards would ensure that that power were used wisely? Obviously, I use the example with, I hope, due caution, but you get the point. If there's going to be a power to bind, then on Kantian principles, we have to have a formal power to, counterbalancing power to make sure that it's not abused. Okay, feudal powers to bind. No argument with the French revolutionary solution. Even if we don't if we don't suddenly guillotine them, we can at least let them wither, as Kant says about noble orders when he discusses those in the Metaphysics of Morals. How are we to think about, though, the situation of corporations which we normally intuitively assume to be defensible, justifiable, an important part of our lives? We've got to think about counterbalancing forms to bind the people who exercise these powers on behalf of corporations. Larissa, have I got 5 minutes? Thank you. So, I might not say all of this, but I want to say something about the means and ends idea by focusing on the perspective of individual participants in corporate organizations and how we might think about binding their exercise of powers. If I have time, I'll say something about outsiders who are also bound because there's a new legal actor in society as soon as a corporation is formed. And I'll say a word about public right if there's time. So, people who exercise the binding power of corporations, you could be the director, you could be the trustee of the British Philosophical Association, you could be an employee of Lancaster University, you could be a member of a trade union. You're doing things that would not be possible in terms of your private rights. I want to say that when you do that, regardless of all those different roles, it should never be the case that the corporation is merely a means for you to pursue your personal ends. I'll stress in a moment, it must also be a means for you, unless the corporation is exploiting you, but it should never be merely a means for you, because then you would be taking on the power of an additional legal person to magnify your own legal capacities, contrary to innate equality, with reduced liability to be bound, because the corporation is the one that's held up in court. So corporate powers protections should never be merely private privileges. You might have heard used, the term is being bandied about at the moment, neo-feudalism, for thinking about some aspects of our economy. And I think in some ways that's a more revealing and helpful term than neoliberalism, which is always very, very confusing. But if you think of the powers of someone like Elon Musk, and all those barons of big tech, they're exercising enormous powers to bind by virtue of the corporate form, and there's something disturbingly similar to the feudal structures. Unaccountable power that no normal person should be able to that's incompatible with equality in our societies. Something feudal happens when corporate powers devolve to individual people to serve their merely private purpose, is my idea. And it could happen at a little petty scale of the tennis club, where somebody's using their directorship to fight a personal grudge against somebody, or it could happen at the international scale. How do we stop corporations being merely a means to people's private ends? They must pursue, my claim is, a publicly justifiable purpose. And the people who take part in them, we should always be able to understand their conduct, their contributions, as a contribution to that purpose. So it might be quite distant. You might be working in the IT sector of a large company. It doesn't really have much to do with anything in particular. Every organization's got to have an IT department. But you might have all sorts of reasons for doing that job and all sorts of motivations. But it should be possible to understand your contribution in terms of the purpose that the organization is pursuing, the university or the business corporation as it may be. Let me turn this means and end point round. So first thought, as an individual participant, you should not be able to treat the powers of the corporation simply as a means to your private ends. At the same time, the corporation should be a means to your end. So I hope I can make this point clearer. So my thought is this. Of course, we have all sorts of motivations for taking part in all the different bodies we're involved in, British Philosophical Association, Lancaster University. We have all sorts of motivations that lead people to take part in different forms of corporate activity. You could have people who are deeply committed. I'll hold myself out as an exemplar, as treasurer of the British Philosophical Association, dedicated to the cause of representing British professional philosophy. I suppose it's possible that I could just care about the extrinsic benefits, the status, the recognition. I might just be using it as a tool for personal and professional advancement. My claim is it should be possible to understand my activity, even if I just care about the extrinsic benefits, as contributing to the purpose of the corporation. That's one claim. It shouldn't be merely a means to my private purposes. It must always be possible to interpret the activity of corporate participants as contributions to the purpose of the organization. At the same time, there must be something in it for the people who take part, and that's why personal purposes, private ends, commitments to civic or professional ends, or just the wage that you receive or the status that you receive. There must be something in it for the people who take part. Otherwise, they would be being instrumentalized for the sake of pursuing corporate ends. Sorry, I'm aware that I haven't explained that quite as clearly as I would have liked. I wanted to say that when we think about the relationship between the participants and the corporation, regardless of what nature of corporation it is, a charity, a church, a trade union, a business, that on the one hand, people should be contributing towards the purpose of the corporation and not using it merely as a tool for their personal ends. At the same time, of course, there must be something in it for them, otherwise they would be being instrumentalized by the corporation. Larissa, am I out of time? Kind of? So let me just say something about the public perspective. So one of the things that get me started on this is thinking about the status of these bodies corporate. Should we think of them merely as means? Can we think of them at all as ends in their own right? I've said from the point of view of individual participants that we should not think of Lancaster University or British Philosophical Association as merely a means to my personal ends. I've got to structure my activity or be made to structure my activity in terms of the ends of those corporate bodies. That doesn't make the British Philosophical Association an end in itself. It just means I may not instrumentalize it. From the point of view of public right, though, Kant is very explicit that some measures may be merely a means, and I think this applies to business corporations in particular. Corporations should either be a means or a mere means towards a rightful condition. I think that's the only way that you can justify them within Kant's framework. So there must be a possible justification to everybody, and perhaps also a democratic justification if we think about public reasoning, about what sort of frameworks for charities law or business law or the university sector we should have in our societies. So, show you a quotation. When I say Kant says merely a means, if the legislator gives laws that support happiness, increase prosperity, and I think that would be the case when our legislators lay down the frameworks for business corporation, they're creating a tool to support prosperity in our societies. They're merely a means towards upholding a rightful condition. I think that's exactly the right way to frame it. Elon Musk should be merely, sorry, no, not as an individual, no. Elon Musk's corporation should be merely a means to promoting prosperity and a rightful condition. If it fails to do that, then we need to think about our framework of law. So, if public rights are going to authorize these bodies that threaten civil equality by giving additional legal powers to bind to the people who take part in them, there must be a justification. Corporations must serve a purpose. It might be essential to a rightful condition. I think that would be the case of political parties. We've got to have those corporate bodies if democracy is going to function, for instance. They might be useful merely as means. That's my example of business corporations and prosperity. We need safeguards to make sure that some people do not use these powers simply for their private ends, but also that their activity contributes to publicly defensible goals. Okay, I've gone over time. Thank you very much for your attention.